Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our Thursday conference call. I occasionally skip these calls if I have too much work to catch up with. Last week we had to skip, so I've got questions from last week. They have been posted, and I marked some of these questions as frequently asked questions. So I'll address those first. And every time I answer a question, I'll ask you if there's a follow-up. Don't ask me a new question. New questions will be kept to the very end. In about 5 or 10 minutes, I might close the conference to make sure that everybody who is here, they get their questions answered. Okay? So with that, I'm going to begin. I wonder if I missed anything I want to tell you. Oh yeah, I forgot the date, September 26th, 2024. That's important for our editors. That's pretty much it. I don't do it one week and I forget what the routine is. Going to the posted questions. The first question that I marked as a frequently asked question was about I-140 national interest waiver, changing employers. Okay. Well, this is a tricky question because technically, what is a national interest waiver? National interest waiver says it's a waiver of a job offer. I should not need a particular job and I should get my national interest waiver. However, if the job is tied to a particular employer, so I say, for example, I am going to work in this field of agriculture. I'm inventing a particular strain of rice which is going to change the way the world lives. So that is my proposed endeavor. That's what I'm going to do. That is the basis on which my NIW is given. Then I change my job and I go to a totally different employer where I'm not doing that anymore. Naturally, it's highly questionable that you can keep your NIW. You'll have to start your green card all over again. But what if I'm working with a different employer but still doing the same area, same job, same endeavor? I think you get to keep your NIW in those cases. So the bottom line, what we look at is not the job, but the nature of your job. If it remains basically the same, I think you get to keep your NIW. I would still not want to take a chance. I would advise you to do a green card through another category or through NIW again. But I think you get to keep it. Anybody has a follow-up question, press *5. All right. Next question, also a frequently asked question, and this is about non-payment of wages and potential H-1B impact. So I arrived in the United States the last week of May 2024, and despite innumerable requests, my employer has not run the payroll. Could this pose any challenges for future H-1B transfers? So yes, for green card and all, it's not an issue. But if you want to transfer your H-1B, you've got to have a darn good explanation why you don't have pay stubs. So in cases like this, I always advise people they should file a complaint with the US Department of Labor. You can Google it, LCA complaint, US Department of Labor, Wage and Hour Division. You can do it over the phone or you can do it online. If you do that, there is a very good reason why you are not getting paid. It's the employer's fault. They are breaking the law by not paying you. Employer is required to pay you whenever you are ready to start work, or 60 days if you're coming from outside, 30 days if you're coming from outside the US, 60 if you're within the US. They are obliged to start paying you. And if they don't pay you, but if you are ready to work now, then they can't just postpone 30 days or 60 days. They have to start paying you now. So whenever you are ready to work, or 30 or 60 days, whichever is earlier. So they are supposed to pay you and they don't pay you, go to the Wage and Hour Division, transfer your H-1B, when the government says, why don't you have pay stubs, you give them a copy of the complaint. There's a good reason why you don't have this. Okay? So that would make it doubly beneficial for you. One, you'll be able to transfer, and two, the wage and hour division will get you your salary for whatever time you're not paid. Okay? So that's what I would recommend. Press *5 if you have a follow-up question. Press *5. I have a follow-up question of some kind from area code 682. 682, I can hear you. Go ahead, please.
Hello, can you hear me?
Yes, I can. Mm-hmm.
Rajiv, I have a follow-up question on the NIW topic.
Mm-hmm.
If NIW is approved for the employer-sponsored, is there a way to transfer it to self-sponsored in the future, like via the same application or
you have to. You have to do the same application again. So for all practical purposes, it's a new NIW. It's not really a transfer. But yeah, you can. You're under no obligation to not file another NIW for yourself. You can. Okay.
Okay.
Good luck. Okay. Area code 716. I'm not taking any new questions at this time. Unless you have a follow-up on what I just talked about, please put your hand down. We'll do new questions. Let me lock the conference. I don't want too many people because we need to make sure people who are here are taken care of.
The conference is now locked.
Okay. So let me see what area code 716 says. New York, area code 716, go ahead.
Yeah, actually, this is a new question.
No, you wait until the end.
Basically,
no, wait until the end. We'll do new questions. I've locked the conference. I should be able to attend to all questions, but it'll be at the end. So let's go to the next frequently. Did I already cover this? Yeah, I did. Then we come to the next frequently asked question. How do I maintain my green card during extended absences for employment? Okay. So what happens is, after you get your green card, you're allowed to make brief casual trips, less than 6 months, no problem. But if they are too frequent, or if you're gone for 6 months plus, you have a problem. At 1 year, you lose your green card. So you have several options. One is to apply for a re-entry permit, which gives you the permission to continue to come and go as you please for a couple of years. And also look at filing N-470. That's another form that helps you. The time here is it's too brief. It's a very long discussion. So filing for re-entry permit as well as N-470, at least re-entry permit by itself may be a good option. And also, if there's a good explanation, for example, your family lives here, your children are going to school here, you have a home here, your job is here, and you're traveling strictly because of work-related reasons, I don't think you're going to lose your green card, but still follow the 6-month rule. Make sure you never travel outside USA for 6 months or more at one stretch. Come back within 6 months each time. If you do multiple trips, you still should be okay without a re-entry permit also. Okay? Press *5 if you have a follow-up question on this. Press *5 if you have a follow-up question. All right. Let's go to the next question. Let me see if I have another follow-up, another frequently asked questions. Okay, this is also a national interest waiver question. Very interesting question, very good question. Rising NIW rejection rates. What's going on? Why are we getting so many NIW denials? And the answer is, it's always a pendulum with the USCIS. They go from one extreme to the other. So right now, they are absolutely obsessed with two questions. Question number one. Let's say you are a neurosurgeon. Okay. You are doing a lot of good work, saving a lot of lives. Healthcare is a good field. It's good for the US. But how is your work helping the US? That is what they are obsessed with. The importance of specifically your work, not your field. So if I say I'm a neurosurgeon, I'm saving lives, they'll say, okay, well, you are helping save lives and helping your hospital. How are you helping the country? Your sphere of influence is only one small area. It is not large enough. So the national importance of your particular job, work, number one. Number two, I'm trying to remember. I just lost the train of my thoughts. So they ask about, oh yeah, then they want to compare your work with other neurosurgeons' work. They want to know, okay, let's say you even have a national impact. How does your work stand out as compared to other people in your profession? So these are the two obsessions of the government: the national importance of your work and your comparative contribution when we compare and contrast you with your peers. Okay. *5, if you have a follow-up question, press *5. All right, let's go on, see if there's any or no more frequently asked questions. Now I just have regular questions. I'll run through these and ask you for follow-ups on these. If there's no follow-up, we'll finish up these questions and then we'll go on to new questions. Let's go to regular question, which is number 4. H4EAD eligibility with early H1B extension filing. I have a valid I-140 and my current H1B is valid till 25. Want to file H4EAD for my wife. She moved to US. They are filing my H1B extension along with H4EAD this month. Can I opt to file the extension in premium so that she'll be able to work as soon as it gets approved? So in other words, what you're asking me is, this is called bundling. If I bundle my wife's application for H4EAD along with my H1B and premium it, will everything be premium? And the answer is theoretically yes. Because there was a case a couple of years ago called matter of Idakuni, if I remember correctly the name. So in that, when the case was settled, before the court, USCIS said, if you bundle your application together with all the three, H1B, H4, H4EAD, we'll premium everything. Sometimes they do it, sometimes they don't. So there's no guarantee it'll work. *5, if you have a follow-up question, press *5. Next question, H1B Dropbox versus H4. This is question number 6. H1B Dropbox versus H4 regular interview. Can you please be a little quick in your raising of your hand? I have to go back now. Wait 1 second. Which is 614? Ohio. Okay. Ohio, go ahead. I can hear you. Oh, sorry. I screwed up. Ohio, can you raise your hand again, please? I messed up. Please press *5 again, Ohio. 614. Okay. I don't see you raising your hand. I'll go to the next question. Okay. Little slow, aren't you? Okay. Go ahead, sir. 614, sir or ma'am.
Yeah.
Go ahead.
So I have the follow-up question. Like, so once it has been bundled, and because my next petition will be valid from February 2025, and if I got the premium now, like, will she be able to work like right away? Like,
No.
I got
No. She can't start working before the activation date. So if the activation date is 3 months down the line, she can only start working 3 months down the line.
Oh, then she has to wait.
Yeah.
3 months. Okay. Thank you.
Good luck.
Thanks a lot.
Mm-hmm. All right. Let's go on to. So what was this? Next question was number 6, right? Yeah, number 6. So I have H1B. My spouse has H4. She transferred from B2 to F1 to recently H4. She's not been to her home country. She came to USA in 2015. I am eligible for Dropbox. My spouse is not. Her interview date is 1st November. Do I need to maintain any gap between my spouse's interview and my Dropbox? No. Why? Do you see any issue of my spouse goes for stamping before I do? Technically, no, but the consulate can insist that, look, we want to see his visa stamp before we'll consider yours. So take your pick. Ideally, you should get yours done first. If my spouse gets 221G, it looks highly likely that she will. Well, not likely, but it is at least possible because she converted from B to F. And that can become a problem because the government can say, well, you lied to us when you used the tourist visa. You had the intention to convert to F1. Talk to a lawyer before you go do a consultation. Why take a chance? Make sure you discuss the details of her case. But yeah, she could get a 221G. What are the options in case of a denial for H4? That depends upon the denial. If the denial is on the basis of fraud, misrepresentation, there is no chance of getting anything done. Very difficult to fight those cases. Can the spouse's H4B denial cause any issues for my H1B? No. No. Not unless the government is attributing some fraud involvement to you as well. Okay. Star 5. If you have a follow-up question, press star 5. Yeah, I want you to talk to a lawyer about your wife's case. Just have her case discussed in detail. I just don't like that B to F conversion. Sometimes if it is not handled correctly, it can become a big problem. Okay? Let's go on to the next question. Number 7. I-140 portability H-1B transfer 180-day rule max out. Okay. I have completed over 3 years of my H-1B in the US. If I switch employers within 180 days of my I-140 approval and the new employer files for an H-1B transfer, will the new H-1B be automatically granted for 3 years due to the I-140 approval, or will it expire on my H-1B max out date? So first of all, here's how it works. If you want to take advantage of H-1B extensions beyond 6 years because of an I-140 approval, your I-140 approval must stay approved for at least 180 days. You don't have to be in the same job for 180 days. So let's say I'm working for employer X. My I-140 gets approved. After 90 days or after 100 days, I leave. Okay. But for the next 81 days, my employer doesn't revoke my I-140. So my I-140 stayed approved for 180 days. I can take advantage of that to extend H-1B with any employer. Why? Because my I-140 stayed approved for 180 days. I don't have to keep the job for 180 days. Okay? Then you mentioned that USCIS might revoke the I-140, and that is a gray area. Yeah. So what is not gray is, if it's a normal I-140, stayed approved for 180 days, whether you were employed for 180 days or not, doesn't matter. You're all set. That's quite clear. It is also quite clear if the I-140 is revoked because of some error they made and they should not have approved the I-140, or fraud or misrepresentation, you lose the benefit of the I-140. There's a gray area. What if they revoke it? If the employer goes out of business? Some of these areas, I'm trying to think of the exact example that I had in mind. Employer going out of work is one very good example. Because there, if the government wants to revoke, they can. There is actually a provision in the regulations, if I remember correctly. Okay, so that is a gray area. But other than that, those I-140s are pretty secure. Would switching employers? Let me finish. I think you have a couple of other questions. All right. Area code 857 has a question for me, which is Massachusetts. Okay. Yeah, let me bring you up. Yeah, Massachusetts, I can hear you. Are you the one who posted this question?
Yes.
Okay, so let me finish answering the other 2 or 3 things you had. Would switching employers before the 180-day mark pose any risk? So that depends. If your employer says, look, I'm not going to revoke it, because they are not required to revoke. Okay, if it is not revoked, you are safe. When filing an H-1B transfer within 180 days, does the end date need to be provided, or will USCIS determine I don't know what you mean. When filing an H-1B transfer within 180 days of I-140 approval. Within 180 days. Oh, so what you're saying is, I changed my job on the 100th day. Will I get 3 years because my I-140 has been approved? Here is the problem with that. Be careful. Because if on the one hand, the law very clearly says 180 days have to pass, what if they red flag it and they say, wait a minute, we should revoke this I-140 because he's no longer working there. They can do that. So that is a red flag that is raised if you leave too early and apply for an H-1B transfer. It has happened to at least one case I saw. It doesn't happen very frequently. The government is not consistently hurting you, but nor are they consistently helping you. So it's difficult to rely upon it. All right? Go ahead. You had some follow-up questions.
Yeah, so just want to reiterate my understanding that if I transfer before 180 days, there is always a risk, even though my employer, like if they don't go out of business and if they don't revoke my 140, but there will be a risk, right?
But how about another option? How about you transfer the employer with premium processing and you don't leave the employer, the I-140 employer, until the H-1B is approved? Okay, so stay with employer X, file for transfer with employer Y, do not change employers until Y's case is actually approved. I think then you are reasonably safe, right? But ideally...
But in that case, they won't revoke my 140, right?
If they try to, you are still working with that employer.
Okay.
Okay.
Great.
So that gives you a little bit more comfort. It's not perfect. Perfect would be the 180 days have passed.
Yeah.
All right.
And how would I know that my I-140 is not revoked?
How would I know my I-140?
Not revoked, sorry. Not touched by USCIS. My employer will definitely not revoke it.
No, they will.
USCIS, how will I know that?
USCIS has to send a notice to your employer before they do anything. They'll send a notice of intent to revoke.
Okay.
Okay. Anything else?
Yeah. Thank you for answering. No, that's it. Thank you.
Good luck. Next question is number 8. Did we do 7 already? Yeah, this was 7. Okay, 8 is another software guy. And he's got a tag, HTML tag or XML tag. Nice. STEM OPT wage discrepancy, I-983 reporting and H-1B filing consideration. I am on STEM OPT, consulting firm for 1.5 months, agreed to pay me minimum wage. I worked 20 hours. I did training courses and projects to gain more skills. My number of hours was supposed to increase. I never got a contract under them. Okay. Are you here in this call? Press *5 if you are, because I have a couple of questions for you. Press *5 if you are here. *5. Okay, great. Let's talk to you. You don't need to tell us who you are, but real quickly, did you pay anybody anything to get this job?
No.
Okay. You did not pay them anything at any time?
No, zero.
Okay.
Nothing.
And,
they never even asked me for anything.
Okay. So I don't see this as a problem at all. I switched employers. Now I have a full-time job. Consulting firm didn't pay me. I do not have pay stubs from them. Would this create a problem? Now, did they pay you for the month and a half that you did do the training and all with them? Okay. But in the beginning, they had promised that they'll pay you.
Yes.
Okay.
Yes.
Okay.
There is that. And plus that is on the offer letter too.
Okay. So there are two sources which govern your right to be paid. In this case, I don't think the federal government can do much for you, but the state government can. Okay. So every state has an agency which is generically called State Workforce Agency. State Workforce Agency. For example, in Washington, D.C., the State Workforce Agency, or SWA, is called Department of Employment Security, DOES, I think. In Virginia, it's called Virginia Employment Commission. In Maryland, it's called DEED. So every state has its own agency, okay? You can call that agency, whichever state you worked in, you call that agency and you say, this employer promised me they'll pay me for 20 hours each week. They never paid me. I want to submit a complaint in writing, okay? Submit a complaint in writing and keep a copy of it. Okay. Whether you get paid or not, normally these state agencies are very tough. They'll go after the employer. They'll make them pay. Because if it was agreed, they must pay.
Yeah. I wanted to ask you one thing. Like, are the pay stubs needed? Because,
Yeah, you may not need it, but
I do not want to get into any hassle like that for the payment because it is not a...
Yeah.
I mean, I don't want to run behind that just for the
then
sake of the
it's
payment.
okay.
But if it is a formality that, or if it is a document that needs to be done, then I would, only if it is the last option, that is when I want to.
But hold on. Hold on.
Yeah.
You've not, if you count that 1.5 months as unemployment. But hang on, we can do another thing. I just thought of another thing. This employer hired you during first year of OPT, right?
No. It was during the STEM OPT. So during STEM OPT, there's a requirement that I need to be paid.
Now,
so
STEM OPT, you
the minimum wage.
You will, and you submitted the 983 to your school, right?
Yes.
You have no choice. You have to file a complaint. I don't see a choice here. Okay.
Yeah, exactly. That is the reason why I wrote this question, because there is that requirement over there by STEM OPT that I have to be paid.
Yeah, you should file a complaint, and that protects you even if nothing happens on the complaint. I think they'll get you the money, but even if they don't, at least you're protected going forward. Okay. Before you do that, you can also talk with your DSO and discuss with them what happened. Is your DSO smart? Do they know what they are doing?
I could try to arrange a call with them and try to see.
Yeah, doesn't hurt, because in the long run, I don't think you're going to have any problem. I would want you to send them an email before you set up a call. Just say that something has come up with the non-payment of my wages. I want to talk to you. Why do I want you to do that? Because I don't want anybody to say that you submitted a fraudulent 983.
Yes.
Okay.
Yes.
And because when you submitted the 983,
I don't want that to happen.
Yeah. When you submitted the 983, you expected to get paid. Then when you didn't get paid, you initiated contact with your DSO. Okay. Talk with them and say that I've talked to a lawyer. They're saying file a complaint against the employer with the state workforce agency. Okay. Do you guys have any problems? Do you want us? Do you want to fix it? Do you want me to withdraw the 9? How do you want to do this? Okay. So by sending, hold on.
There's one more problem.
Hold on.
Okay. Yeah,
by sending an email that something has come up because of non-payment of wages, I want to talk to you. So by putting that in writing, you are creating a record that nobody can hold you to fraud. Okay. And other than that, there is zero problem. I don't see any issue. Okay. Now you were saying something. Go ahead, please. Yeah. You were saying something. Go ahead.
Yeah.
You forgot?
Yes.
That's okay. You can just raise your hand again.
This thing regarding you're saying about the other option, like if they think of revoking it. I do not have, I have only a very short time left on my number of unemployment days. So, that option should not be applied. So I'm in kind of very,
then you're okay. By the way, did they assign your report? They're supposed to report, and they are supposed to actually, if they let you go or if you leave the employment within 10 days, you have to inform the DSO anyway.
Yes, I did that. there's a form which I had to submit before joining the job, and then even after exiting, and I did all the formalities are done. Even
Okay.
they signed it.
So that
everything
is
done.
wonderful.
Those formalities are
That is
done.
very good. That makes me feel quite comfortable that you're not going to get into any serious trouble. Okay. But let's also make sure that you take that one extra step and discuss with your DSO that you have non-payment of wages. Should you file a complaint or not? What does the DSO suggest? And if they say don't file a complaint, come back and talk to me in the conference.
Okay. I'll even talk to the company once again. They were a little bit how do you say, they were angry that I left. But the problem is, I mean, it becomes difficult to survive, without anything. And so that is why. And after really a lot of applications, I finally got a job.
Yeah, no, you can.
So
Talking to the DSO is absolutely essential. Talking to the company is up to you. Okay.
Okay.
Good luck.
Okay. Understood.
All right. Take care.
Yeah. Thanks.
Bye.
Thanks, Rajiv.
No time. No problem.
Bye.
Okay. I was going to say any time and no problem. It became no time. Oh, well. I'm not perfect, I guess. Number 10. Question number 10. H-1B extension pending DUI case risks and factors. I'm on H-1B, charged with DUI, case is in court. No, the extension should not be impacted, but don't travel, okay? Should I wait to file for extension till I get a decision on my case? I don't think so. But if you can get a quick resolution of the DUI and it gets dropped down to something like a normal traffic offense, then you have no problem. Will I get an RFE on my extension because of the DUI? I don't think so. You should also do one thing. Talk to a lawyer, immigration lawyer, who does deportation defense in the state where you live. I don't think you are deportable, but it helps to know where the pain points are, because DUI comes in many flavors. Normally DUI is a felony, okay, and it can be a ground for removal because it's intoxication and abuse of controlled substance. I don't know. There are several different categories. You should talk to a local lawyer, immigration lawyer, who does deportation defense. They can answer your question very quickly about any problems because of these charges. And they can also coordinate with your criminal defense lawyer to make sure you get the best deal which the prosecuting attorney would be willing to give, and it does not impact your immigration status. So you should be fine. But, I think DUI is very irresponsible, guys. Cars go very fast in this country. Please watch out. Don't kill yourself and other people. So that's pretty much it for this question. Any follow-ups on this DUI issue? *5. Press *5. Okay. Number 11, B1, B2 extension, clarifying case status unavailable. I applied online for B1, B2. The case says, the status says unavailable at this time, 9 days later. What can I do here? Immediately contact the USCIS customer service, talk to the helpline, find out what is going on. And if they don't help, open a case with the USCIS Ombudsman's office. These glitches online are not uncommon, but I don't want to let it slide. Okay? So talk to the customer service. *5, if you have a follow-up question, press *5. Question number 12, which is, I'm currently on medical leave. I'm on F1 and have my H1B picked and approved. Will being on leave on October 1st impact my change of status? No, it does not. Especially where you have medical leave. So I do not see why this should be a problem. Even if you are on leave on October 1st or even October 15th, as long as you have a medical reason for it. Just because you were not able to join does not lose your H1B. If you join on October 16th or 17th or 20th, you are still okay. *5, if you have a follow-up question, press *5. Question number 13. Switching from H to B and spousal considerations. I am transitioning for B1, B2 to H1B and H4 for my wife. Can I file Form I-539 for both myself? No. B to H conversion does not go through 539. It goes through I-129, which is filed by your employer, not by you. Your wife's I-539 will be based upon your I-129. You can't do an H-1B yourself. Once I get a job, would the new employer file for a transfer of H-1B? If you are on a B1, B2, they'll file for a change of status. I have an article written on this, very small 800-word article, on my Economic Times page. So just Google my name, Rajiv S. Khanna, Economic Times, and you'll see that article that talks about conversion from B to H and then back again. Do I need to separately file for change of status back to H4 for my wife? Yes. Would my wife get her EAD back? She has to file a new one. Okay. Press *5 if you have a follow-up question. Press *5. I think that's the end of our posted questions. Okay. Anyone who has any question, press *5. Now it's time for new questions. Anyone who has any question, press *5. So far, I have only 2 people who have new questions. Okay. So in the order that I see that you logged in, first one will be area code 732, which is New Jersey. New Jersey, go ahead, please. I hear you.
Hello, sir. My name is Divya. I have a question about H4. My H4 status was approved on January 1st and start date was March 1st.
Mm-hmm.
In between, I traveled to India and come back on my F1 status, which was valid.
Mm-hmm.
So right now, I have applied for H4 extension and just got RFE saying that you are no longer considered H4 as you came back on student visa.
Mm-hmm.
So you are no longer able to get extension.
Mm-hmm.
And also in my H4 extension, I have provided I-94 and H4 approval notice, but I added that I-94 from downloaded, not the one that they're providing H4 notice. And also, like in additional document, I have provided my H4 approval notice. So what are my options?
Well, you definitely have a problem because you traveled while the change of status was pending. Okay. So
No, it was already approved. H4 status was already approved before I traveled.
before you traveled, your H4 was approved, but you did not get an H4 visa stamp. You came back on F1 visa.
But the effective date was like March 1st. Like my status got approved on January 1st,
Okay.
and my effective date was March 1st.
And
I
you
traveled.
you returned before March, before the effective date.
Yes.
Okay.
Yes.
So
yes.
you
2 months
returned.
before.
Hold on. You returned before the effective date. So let me get this straight. You were on F1. You applied for conversion from F1 to H4. It gets approved. Then you travel. You
Yes.
come back on F1,
Yes.
but the H4 is not yet active. It's supposed to be active a month or 2 down the line. Then you should be okay because
Yes.
then it looks everything is okay. When you entered back, you were still a student
Yes.
and you went to school when you entered.
Actually, I was on OPT, so
Okay, same
my
thing.
student
Same
visa
thing.
was
Same thing. That's good enough.
like, 5.
So then you can respond. Was this an RFE or a denial?
RFE.
Yeah, so RFE is easy to respond because you are fine. I don't see any problem here. Just respond to them and explain to them the timelines. They should be able to give you an extension. I don't see any problem here. Okay.
Okay, and but the thing is, I also sent the approval notice and my H4 EAD too, like with this extension while I was extending this H4.
Mm-hmm. So what?
So
None of
what
that.
should
None of that matters, ma'am.
Okay.
You should be able to get your extension because you did have an H4 that kicked in the future. So you should be okay. I don't see any problem with it.
Okay. And may I know what should I send them in response? I will send them the explanation letter, of
Ma'am,
course, but the document wise.
I would recommend get yourself a lawyer. Let them do it. It is not extremely complicated, but I'm sure your lawyers will be able to do a little better job than you can. All right? Just get yourself a lawyer.
Okay. No.
You can work with your husband's H1B lawyers. It's not a complex situation. It's a straightforward thing. Okay?
Okay, no problem.
Good luck.
Thank you.
You're welcome. All right. Next is New York, area code 716. New York, go ahead. How can I help you?
Yeah, hi Rajiv. So right now I'm on my H1B. Actually, my employer, he filed my H1B on a counselor process based.
Mm-hmm.
So is there any way that I can get the document from my employer, because my college is asking me to submit that document because they want because there was a basically a wrong interpretation there that it was given as change of status. So the college is asking me for my H1B document approval because they wanted to keep my F1 status.
You can let your employer know that the college is asking for it, go ahead.
Yeah, actually, I asked my employer, but they're like, we will not be sharing the document with you because generally they don't ask for the document. But
Well, they are worried.
The mail, but they're not.
They are worried that you will leave them and go. No, that's the problem. So I don't know. This is really an issue of a conversation that needs to happen maybe between the school and your employer. One of the things you can do is you can tell the employer, I'll give you an email address of my DSO. You can send the notice directly to them. You don't have to give it to me.
Okay. And suppose right now, suppose it's a council process, right? So right now my H1B is not yet activated. So can I shift to a new employer and just
that nobody can answer. I've answered that question a million times before. If you just listen to the frequently asked questions, go to immigration.com, go to the frequently asked questions. I've discussed this issue in detail so many times.
Okay.
So it's definitely a risky thing to do, in my opinion.
Okay.
Yeah.
And even that my employer told me that he would activate my H1B next year, in 2025. So can he activate it any period, any month in the year, or it should be only after October? Is there any rule?
No. If your current H1B is effective from January of this year, your current H1B.
No, actually, it should be effective from October 1st.
Was it approved October 1st?
It on hold and they asked me.
Was it approved October 1st, 23?
No, actually, it got approved this year.
So it was effective, or it was supposed to be effective October 1st. They can activate your H1B any day going forward from now. So they can do it today, tomorrow, day after tomorrow. It doesn't matter. Okay. They don't have to wait till October.
So, and one more question. If my head. Okay. And one more question is that if my H1B transfer, suppose if it's a riskier job and not possible, can I again enter the lottery again next year, or would it be a problem because all my H1B petition is already filed once?
I would try it because this is a weird situation. The H1B is approved but not activated. Okay. I would try my lottery again. Why not?
Okay. Is there any risk kind of?
Well, remember, the restriction is against multiple filings in the same year.
Okay.
You're not doing multiple filings. One you did last year and one you'll do next year.
Yeah.
What is the problem? Okay.
Okay, so that should be with a new employer, right? Not with the same. I think the same employer wouldn't obviously.
Yeah, why would
a
they
lot
do
again.
it?
So it should be with a new employer.
Yeah, why would they do it? Exactly.
Yeah.
All right.
Okay. But is there any way that I can get the document from my employer, like, because
No,
it's
you
not,
cannot.
they are not sharing the document.
Look, if
Okay.
you look at the approval notice, it clearly says you are only entitled to the I-94 if your I-94 is approved. Yours is not because it's consular processing. Okay. So are you entitled to a copy of the notice? Probably not. Are you entitled to a copy of the LCA? That by law you are.
Okay.
Okay.
Yeah.
Good luck.
Okay. Yeah. So thank you.
You're welcome. All right, folks. That's all the questions we had today. Good talking to you. Hopefully I can see you again. Oh, there's another question. New York, go ahead.
Hi, sir. It is just a follow-up to the previous question. Like, one of my friend is in similar situation. So, I mean, this sounds weird, but is there any way, like, my friend can go to India and get her H-1B stamped when it is approved in consular processing?
Without the employer's help?
Yes.
Very unlikely. Because normally they want a confirmation of employment from the employer.
Okay.
Okay.
Okay, sir.
Good luck.
That's it.
Good luck.
Thank you.
You're welcome. All right, folks. Good talking to all of you. Hopefully, I'll be able to talk to you again next Thursday. These days, work is extremely busy, so sometimes I just can't make the time, but I'll try my best. Thank you all for being here. Take care. Bye-bye.